Welcome, my fellow FPA members, to our FPA Political Action Committee virtual reception here on February 8th. Thank you very much for joining us. I'm Skip Schweiss. I am chair of the FPA PAC board last year and this year, and wanted to take an hour this afternoon to share with you what's going on with your PAC, the only PAC representing the interests of financial planners, as well as to look ahead at where the PAC is headed, and most importantly, from our Inside the Beltway expert, Dwayne Thompson, hear about what's going on in DC that could impact your practices and your clients. And then we'll leave a few minutes at the end for Q&A. So Ben, I assume people can enter Q&A in the chat.
Yep, that's correct.
Okay, thank you. And I will monitor that while Dwayne is speaking and moderate the Q&A at the end. So with that, let's take the next slide. Okay, I want to share some data with you on your PAC. So this is the last 5 years worth of number of contributors. I told a fellow board member I'm a skier and I like downhills, but not this kind. Last year, we had all of 97 people, 97 FPA members contribute to the PAC. That is, if you can do math better than I can, if you divide that into about 18,000 members, that's just a hair over 0.5% of our FPA members contributed to the PAC. So next slide, please, Ben. This is the total contribution amount. This number has been a little steadier, you might say. We, for whatever reason, had a nice spike in 2022. But other than that, 2023 has been our high water mark. So that is good news. So next slide, Ben. And again, just doing some math, the last slide divided by the prior, the average contributor is giving a little over $600 a year. Last year, a little over 600. And that number continues to climb. So just to maybe summarize the last 3 slides, we are seeing fewer FPA members contribute to the PAC, but those who are contributing more. So that is the good news. I'm always looking for the silver lining. Next slide, please, Ben. This is our PAC bank balance. So we're going to get into this more in a few minutes with Lauren, but ever since the events of January 6th of 21, the FPA PAC has not contributed to any political campaign. There were quite a few PACs in that era that decided to simply disband. Some decided to simply put a pause on political campaign donations, which is what we did. So as a result, our bank balances are growing. Now, you might notice that we have $201,000 in the bank as of the end of the year, $185,000 last year. That differential is $16,000, and you might be saying to yourself, wait a minute, I thought I saw our contributions last year were something like $59,000. Where'd the rest of it go? It does cost money to run the PAC, and we're looking for ways to streamline that. But we do have expenses, legal and accounting expenses, expenses to sometimes put on receptions at FPA events, things like that. So that's where that differential goes. Next slide, please, Ben. This is our 2023 top contributors list. So these are people who gave the PAC at least $500 last year. We're very grateful to each of these people. And I think if you do a quick eyeball scan of this list, you'll see a lot of names you recognize as people who are contributing not only their treasure to the PAC, but who have contributed an awful lot of their time and talent and energy to the association and to its and to the profession. So you'll see this in the journal in coming months. We always publish that in about the springtime to make sure we're properly recognizing these people who are contributing so much to the future of our profession. So thank you. Next slide. Turning our attention ahead a little more, this is your 2024 FPA PAC board. Myself, Dean, and Evelyn are returning members from last year, and we recruited Shannon, Chris, and Lance to join us on the board this year. Very appreciative of Lance, Chris, and Shannon joining us. Shannon is one of those who just keeps giving and giving to this profession. I had the great honor of serving alongside him on the FPA board for at least a couple of years. It seems like there's a little bit of a theme in the male haircuts here on this in this cadre too. But on a more serious note, one thing I want to call out is you might notice there's not a tremendous amount of diversity on this board. Thank you, Evelyn, for giving me a little bit of an out there. But we would welcome additional board members. I always like to shoot for an odd number in case you have contentious votes of some kind or something. It seems to work out better that way, but we would certainly welcome more board members, and we would certainly welcome more diversity in our PAC board. So I'll just plant that seed with you. Next slide. Okay, these are the FPA advocacy priorities. We all are very familiar with the Title Protection Initiative. We're also backing financial literacy and wellness initiatives, which primarily come out of the states, and we're certainly seeing some progress in that arena. Financial planning fee structures. We know that some states have concerns with subscription fees, and we sometimes have to address those. And taxation of financial planning services. From time to time, states will introduce legislation that might impose, for example, a sales tax on financial planning fees. That showed up in Kentucky a couple of years ago. My understanding is there's a bill in South Carolina that may show up in this legislative session there. So we're always keeping an eye on those kinds of things to make sure that clients don't even have to pay more for your services in the form of something like a sales tax. So all of these things, to whether we're playing offense or we're playing defense, and public policy advocacy certainly requires both. It requires time, talent, and treasure, as I always hear in my church. It will require people going to their state advocacy days, people contributing to the PAC, people delivering their energy to defend the priorities of the financial planning profession and continue to build and advance the profession. So I really would call on each of you to look in your heart and ask how you can contribute, whether it's financially or time-wise, to helping build the profession in the public policy arena. Next slide, please, Ben. Okay, looking back again, this is the last election cycle, and this is how the Federal Election Commission looks at PAC fundraising when they report it. This is all public information. These are some other PACs in the financial services arena. NAFA is the insurance financial advisors, ICI is the mutual fund companies, SIFMA is the big broker dealers, FSI is this not necessarily small, but independent broker dealers. And there's FPA representing financial planners. I think a picture tells 1,000 words here, but advance to the next slide, please, Ben. And I just have this vision, if the other 99.5% of FPA members each contributed $50 to the PAC, look where that would place us in the league tables. We would be right up there with some of the biggest contributors, some of the most active players in our space. And I don't think I probably have to call out, we may sometimes agree with these other associations on policy issues, and we may sometimes not necessarily agree with them. So, but we really need to be in the arena when it comes to public policy. Next slide, please, Ben. So here is your chance to contribute. You can take a snapshot of the QR code here, or just remember fpapac.org. It's easy to go there and make a contribution. We welcome, and every month we get contributions from $50 to $1,000 or $2,000 or $5,000. So I always say whatever fits your budget, whatever you feel comfortable or maybe slightly uncomfortable contributing to your PAC and your association's ability to advance the interests of the profession. Next slide, please, Ben. Okay, so I'm going to transition this over to Lauren. I mentioned earlier that the PAC has not made a political contribution to a campaign since January of 21, so 3 years. So our pause ended up being longer than we thought it would be. In the interim, we did change our bylaws to also allow the PAC to PAC funds to be used for lobbying expenses, which can be very effective in helping advance the cause. But we are ready to begin in 2024, and it is obviously an election year, contributing to political campaigns again. Now, I know in a lot of my conversations with members about the PACs, people will say, well, are you giving money to so-and-so, or you're not going to give money to so-and-so, are you? Or this party or that caucus or whatever. That's not how we do this. It's not about party or partisanship. It's about what elected officials have demonstrated that they are standing behind the interests of the financial planning profession and our ability to serve our clients. So we've crafted a plan for that, and I'm going to turn it to Lauren to lay that out for you.
Thanks, Skip. And if anybody has questions, I can't see the chat while I'm presenting, so feel free to holler or put them in the chat, and maybe Ben can moderate those for us. So we do have a PAC board approved candidate contribution set of guidelines, and the detailed version of these guidelines is available in that 2023 end of year report that was sent out last week. And so people can read a little bit more detail about what went into those, but there's essentially 5 primary questions that we are asking ahead of contributing any funds to any candidates. And Skip, kind of went over these already, but have they directly supported any of our legislative initiatives out of those 4 core policy issues? Do they currently have a position on a committee of jurisdiction or a leadership position in their political party or on a committee of jurisdiction? Do they support FPA social diversity and inclusion policies in the workplace? And is the elected official in good standing? And so what we did this year is we took these guidelines and we actually implemented them for the 2024 election cycle. And primarily we are focused on federal representatives at this point. So because all 435 seats are up for re-election, that's a huge number of potential candidates. So we are primarily focused on the House with some focus on the Senate, specifically for a couple of targeted positions and people. So these are the 7 steps that we have applied to narrow down from the hundreds of people that we can possibly contribute to the ones that are going to be, we think, the most impactful. So importantly, we're starting here with legislative history for our incumbent candidates. Obviously, if they're a new candidate, they don't have legislative history in Congress. So we utilize a tool, probably most everybody on this call knows this. We utilize a tool called Voter Voice for our grassroots campaigns. So when y'all have taken action on the Freedom to Invest in Tomorrow's Workforce Act, or any of those other federal pieces of legislation, that's through Voter Voice. It's a great tool because it allows us to keep track over several years positions that FPA has taken on various bills, and it allows us to pull together a voter voice scorecard for each member of Congress based on their voting record on the bills that we care about. I'm going to show you an example here in a minute. We then narrow down, out of all of those representatives who had the ability to vote on bills that we care about, we narrowed it down to only those representatives with aggregate scores of 100. That means they voted the way we wanted them to vote on every single piece of legislation that we took a position on. Because we're looking back to as far back as 2017, we had to, of course, determine if somebody who met that first step was a current representative. Are they seeking re-election? Have they co-sponsored legislation that's important to us, like the Freedom to Invest in Tomorrow's Workforce Act, which hasn't had an official vote yet? And then looking at some of the details, what is their occupation? Is there anybody in financial services? Are there any financial planners in Congress that we might want to support? And then pertinent notes related to that good standing requirement. So these are the bills that I looked back at our history of the positions that we've taken from 2017 to present. These are the federal pieces of legislation that we have taken action on over the course of the last few years. From that, Voter Voice gave me a scorecard that showed a list of 575 representatives. It told me what their score was for each session, and then what their aggregate score was. And because we only have a handful of bills, the scores are, 0, 50, 75, or 100. You might be asking, why are there 575 representatives on this list? It's because some of them are no longer in office, but they still show up on the voting record. And then, like I said, we narrowed those down to only those folks who had an aggregate score of 100. That was step 2. For step 3, I then went through the entire list of representatives and pulled out the folks who were not current representatives. I then went through the whole list of current representatives and identified whether or not they had filed their bid for candidacy. So whether they had filed for candidacy for this election cycle, and removed those folks who are not seeking re-election in 2024. I then went in and added a column for whether or not that particular representative had agreed to co-sponsor the Freedom to Invest in Tomorrow's Workforce Act. When I made this, there were maybe 30 co-sponsors of that bill. Now there are 114. So that bill has really picked up steam since we first started working on this process, and we'll need to update it as we go. I also have some just additional notes from our DC Advocacy Day. So, for example, Pete Sessions from Texas at this time had not co-sponsored HR 1477, but I know our folks who met with his office during DC Advocacy Day had a fantastic conversation with him and his staff. And so, I just put in certain notes about personal interactions that our members had with those legislators. I then went through, and for all the folks who are still on the list after those steps, looked each member up, identified what their occupation is outside of being a legislator, and then through basic Google searches, media searches, identified folks who had issues that I think would impact this good standing. And those are situations where somebody has violated a federal or state law. Maybe they've been involved in lawsuits, other things and then we also identify good standing as, are they upholding their oath of office? So in this example, you can see this one representative from California that I just noted. He had lost a lawsuit in an employment case for employment law issues on his dairy in California. And so I wanted to make note of that for our PAC board to be able to assess. And then on the flip side, you see Representative Kim Young here from California was a financial analyst for First Interstate Bank. So I noted that she has sort of a nexus to the financial world. Another thing that I don't have on here at the moment, but we will add, we really want to consider donations to those representatives who are members of the Financial Literacy Caucus. So we met with a fair number of those folks at DC Advocacy Day, and they obviously have taken a strong stance on an issue that we are very, we're very active on at FPA. And then just to show an example of how we are going to analyze this situation on the Senate side. So y'all probably know the Senate doesn't have very many actual votes on pieces of legislation. It's pretty rare that the Senate actually votes on something. And for our issues, they haven't actually taken a vote on a bill that we have taken a position on in this same time frame, 2017 to present. So what I did is focused on leadership positions for committees of jurisdiction. So that's going to be Senate Finance and Senate Banking, Housing and Urban Affairs. And then really digging down onto those folks who are co-sponsoring the bills that we are focused on in the Senate. So there's the Senate version of the Freedom to Invest in Tomorrow's Workforce Act, and then the House version of the Financial Exploitation and Prevention Act did pass out of the House unanimously. There is a Senate version that has now been picked up, and we have 3 co-sponsors for that piece of legislation. So in the House, we would also focus on possibly identifying individuals who are in positions of leadership for the House committees of jurisdiction. So that is the same in both chambers. The last thing I want to point out is some of the applicable laws for our PAC as we're thinking about contributing. So on screen right, I guess, my left, you can see the contribution limits per candidate for 2023 to 2024. So we are ultimately going to be contributing as a multi-candidate PAC. So you can see on the right, I have shared a screenshot of to qualify as a multi-candidate PAC. We're an SSF, which is a segregated fund because we are a connected PAC. We're connected to FPA as an organization. So to qualify as a multi-candidate committee, we have to have received contributions from more than 50 persons, which we have, and we have to contribute to 5 or more federal candidates. So we are going to be looking at that $5,000 per election contribution limit. Conversely, if we didn't meet the above guidelines, we would have a $2,300 limit for elections, for election contributions. And then next steps. So in the immediate future, we are going to be identifying, we need to first identify the amount of money that we want to contribute in total. And then we need to identify how we're going to be dividing up those funds. Are we going to use a tiered structure? Is everybody going to get the same amount? Those are details that we still need to work out. Using the process we just discussed, we need to figure out who from the incumbent list is on that we're thinking of. And then in particular from the incumbent list, we need to identify any champions that we already know of that have difficult primaries. And Senator John Tester is an example of that. As a champion, has a difficult primary. So we are going to want to act on that before the general election. For the rest of the contributions, we're going to be focused on the general election as opposed to the primaries. And we have plans to send out a candidate questionnaire in the spring. We're still working on finalizing those questions. And then in the summer, we'll want to review all of this data, make final decisions, and deliver checks. So that is what we have for next steps. And that is all I've got.
Okay, we're going to turn it to Dwayne, the headline act in today's concert. And Dwayne, I believe you're going to share your slides.
Yes, I am. And let me make sure I'm at the right place. Tell me if you all can see that.
We got it.
Okay, well, welcome everyone, and Skip, thanks again for inviting me to do a quick overview for you all, and I promise you it will be quick. The overview will be quick too, because there's quite a few things, and I won't be able to dive into much detail, but during the Q&A, if you have any questions that I can help with, I'm happy to try and help. So I tried to look at obviously things that are of direct interest to financial planners, and that certainly covers the waterfront, given your holistic view at that delves into a lot of different areas of regulation. But I broke it out into legislation, regulation, and the courts. Looking at the Secure Act 2.0, which of course passed just over a year ago, and technical corrections bill. That was such a massive bill. There was some oversight needed to make some corrections. The DOL fiduciary rule, of course, is top of mind for a lot of people. Just give you a look at what poison pill amendments are. A few tax breaks that were actually passed by the House of Representatives a couple of weeks ago. And just talk briefly about fiscal policy and government shutdowns, not because that affects everyone, obviously, but in case you get any client questions on that. Regulation, I'm going to look at some SEC rules, a couple DOL, and some ongoing Secure Act guidance, and also the courts and the increasing role that they're playing in regulation in particular. So looking at poison pill amendments, if you've never seen one, I thought it might be interesting to see actually what they are. And so these are several amendments that were passed by voice vote to the annual appropriations bill for the Department of Labor. And for example, the amendments would prohibit funds by the Labor Department to finalize, implement, or enforce proposed amendments to class prohibited transaction exemptions available to investment advice fiduciaries. So what does that mean when you prohibit funds? That means the attorneys or anybody in the department, or if they outsourced any of that work to someone to actually work on the rule, rewrite it, hold meetings, et cetera, you couldn't use any funds for it. So it essentially kill it. And there were a couple other, just to make sure they didn't miss anything, a couple other poison pills. Now, in realistic terms, these usually they're sort of messages that are sent out there, and they usually don't make it into a final bill. And in the last couple of years, at least, and longer, because Congress typically fails to pass, I think there's 12 appropriation bills on time. They typically bundle it all together and pass it all at once, and so these poison pills get eliminated. But I thought it'd be interesting to see what they look like. I'm also going to briefly go over a technical corrections bill where there's a draft discussion bill that was released in December. I know this tax deal that just passed the House really doesn't have much of a direct effect on financial planners with their retail clients. But a lot of folks are looking at it to see when the 2017 tax cuts come up for potential renewal. This is kind of a little bit of a test case to see if Congress will be able to work together on that larger picture. And again, looking at the government shutdown. Regulation, the rules that I thought would be of most interest are obviously the ones in which financial planners are registered as investment advisors with the SEC. And there's 5 rules in particular that are pending. One is amendments to the custody rules for investment advisors. And this rule would essentially broaden the custody from stocks and bonds that an investment advisor may have in their possession to any client assets. That's a bit controversial. There's another rule, outsourcing by advisors. Third-party service provider oversight by RIAs would require due diligence prior to engaging these service providers. And when I look at this in the bigger picture, it kind of reminds me of ERISA, where you have obligations of plan fiduciaries to make sure they undertake appropriate due diligence of the investment advisors they hire to manage their plans and so forth. So in a small way, when I look at this outsourcing by advisors and outsourcing by ERISA plan fiduciaries, they seem to be, it's certainly not coordinated, but they seem to be moving closer together. Then, of course, ESG has been in news quite a bit. One of the rules that the SEC is considering are disclosures by investment advisors and mutual fund companies on any ESG type strategies that they use on behalf of their clients. So if you don't use ESG, this rule, if it is passed, wouldn't affect you. Cyber security disclosures is another one that would require the securities industry, including investment advisors, to report significant cybersecurity incidents to the commission and also to disclose to their clients. Now, all the rules I just mentioned, there's what's called Office of Management and Budget dashboard, where they ask the agencies twice a year to project when they're going to adopt these pending rules. And all of these rules, including the digital predictive analytics rule that's on the screen, the SEC says they plan to adopt by April of this year. And so I want you to remember that date, because we're going to go into it in a different way. There's also a rule that was adopted last year, documentation of annual compliance reviews by an investment advisor. Obviously, that rule's been out there for a long time. The states also have a roughly comparable rule a model rule that they approved a couple of years ago, but the deadline for documentation of these rules is September of this year. And as we all know, there's the Department of Labor's retirement security rule package that is pending. It was released October 31st. Comments stopped early January. That's certainly getting a lot of attention. Secure Act 2.0 guidance is ongoing. I'm going to touch on that in a minute. This other rule, I don't follow that closely, but it's a big deal. Skip had mentioned FSI and the Independent Broker Dealer Network. That's a big deal for them, where the Department of Labor went back and revised a Trump administration rule that made it easier to define someone as an independent contractor as opposed to an employee. And basically, the Department of Labor pretty much pushed out that rule and made it much tougher made it much easier to classify someone as an employee with the business they're associated with, and that covers a lot of businesses, trucking businesses and IT people, but it also apparently covers in particular, independent broker dealers and their affiliated investment advisors. It's important enough to FSI that I noticed a lawsuit has been filed by a coalition that includes FSI to overturn the rule in the Fifth Circuit. So that may be of interest to some FPA. I know it would be of interest to some FPA members. Finally, the Department of Labor also has an ESG rule that allows the use of ESG type funds in 401k type plans. And again, the Trump administration had made it more difficult to use ESG as a factor in determining selection of prudent investments in a plan. And it also banned the use of ESG options in QDIAs. Now, that's not a really big issue in a way because not a lot of plans have clear ESG type investments options available. But that's also under court review. There were 25 what I call red state attorneys general that attempted to overturn the rule in a Texas district court a few months ago, and that has also been appealed to the Fifth Circuit. And finally, in particular interest for state registered investment advisors, and I know there's a fair number who are FPA members, there's work underway on a testimonial rule or marketing rule for state RIAs that would be comparable to the SEC's rule that went into effect, I think it was November of last year. That would allow, since 1960 or 62, client testimonials had been banned by the SEC, but now they're available. And so there's NASA has a special project group that's looking at drafting a comparable rule. And I would say, speaking of Phoenix, I live in Arizona now, and I do a little volunteer work with the Phoenix chapter, and they're getting ready to meet with their state securities director to see if, in the meantime, if it takes NASA a long time to come up a rule, if they could come up with a streamlined rule that allowing client testimonials by investment advisors. So I think that's an example of a chapter involved in regulatory affairs in a positive way. And Skip had also mentioned subscription fees. That is becoming a bigger deal. I have a client, XY Planning Network, that primarily charges subscription fees, basically monthly type fees for financial planning services, and not with any ongoing investment management allowed. But some NASA state securities regulators have concerns with it, and I couldn't get any detail on it. I think most of it is unfounded. But there's a lot of emotion involved in that issue. I was at NASA's annual meeting last fall, and I had what I was hoping to be a positive conversation with the state securities regulator, and she said, if you all keep doing that, you all meaning the financial planners that use subscription fees, that it's going to be banned. I think that's an outrageous statement to make, because I think somebody would lose very quickly in court if they tried to say this was, you know, you have to, they have the discretion in order to say how you get your compensation. And as long as it's reasonable and disclosed and so forth, shouldn't be a problem. But anyway, that's some of the issues that I think are out there under regulation. So I'm probably not going to have much time to go into Secure Act, other than to give you a little highlights. There was some confusion when the law was passed about the required minimum distribution age. It's now 73. If you attained for a retiree who attains age 72 after December 31st of 2022, the legislation will clarify that the RMD jumps to age 75 for those who reach age 73 after December 31st, 2032. So when you have a massive piece of legislation that Congress actually has a lot of bipartisan support with, and this was hundreds of pages of incentives for encouraging retirement savings and so forth. So it had very broad and deep bipartisan support, and they should be commended for ambitiously including all these different provisions. But when you have that many in the last minute rush to get approval, sometimes there's some clarification that's needed. So the ones I have on the screen are some of them. One I would mention is there's if you're curious, a lost and found retirement account database. And that was in the bill that for folks who, you know, a lot of the workforce is mobile. They'll leave behind some money in a 401k when they move to a new plan. And this would be a website that the Department of Labor would be required to develop to allow access for finding that lost retirement income. And so the technical corrections bill just added that the types of retirement accounts that would be included in this database would include IRAs and deferred annuity contracts and things like that. And also, because this bill phases in a lot of some of the different changes, starting beginning of this year, student loan matching provisions where the employer can match the loan payments that the worker makes back for a college loan, that kicked in. It's only one record keeper I've heard of that's started to provide that service to plans, and that's Betterment. But that may increase over time. There's emergency savings account provision of $2,500 that can be piggybacked on a 401k type account. When I look at some of these, including ways to avoid a 10% penalty for terminal illness distributions, et cetera, you know, it seems to me that Congress, in a way, is unconsciously getting into the financial planning business, because I know any financial planner worth their salt is going to encourage their clients to put away 3 to 6 months of savings in the event of an emergency or a termination from a job and so forth. And so it looks like Congress is interested in helping you out a little bit. And there's also going to be a request for information on disclosure effectiveness in Form 5500 plans to help participants better understand their investment options and so forth. So, you know, I can imagine that over the last couple of years, some of you may have gotten compliance whiplash, where you've seen, for example, in the Trump administration, some reversals of policies from the Obama administration and vice versa under the Biden administration. And this just gives you an example of how some of this whiplash can occur. And so this could occur if, let's say, you have a new administration that comes in that doesn't like the policies of Biden, that President Biden has put together. You would need to have pretty much undivided government. You'd have to have, you know, control of both chambers, House and Senate, and the White House. And typically what we've seen the first 2 years of the Obama administration, the first 2 years of the Trump, and the first 2 years of the Biden administration, they've had control of both chambers and the White House. And so that's the only time where you've seen legislative activity that's resulted in new laws. Other than that, when you get into divided government and the intensity of partisanship, it's pretty hard to get things done. That's what makes the Secure Act 2.0 an exception. There are a few exceptions there, but overall, it's really, really hard with partisan gridlock to get anything passed in Congress. But that's a potential minefield. Congressional Review Act, I'll get into that in a minute. But that's a streamlined process that was passed by Congress in the late 90s to make it easy for Congress to overturn rules that are adopted by federal agencies, that they could certainly try and pass legislation to do the same thing, but it's difficult. And so this is a streamlined way to do it. I already went over the poison pill amendments that could have the potential to overturn rules by taking away their funding. And then judicial review is being increasingly used. And of course, if you have a new/old person in the White House, it looks like we already have the two candidates locked in. You could see rules watered down or overturned, as we've seen happen between the Obama and Trump and Biden administrations. So I wanted to look at the 2016 fiduciary rule, because I think we're going to see a rerun of it coming up. And I think when you start to see the news stories and everything, you might have a better appreciation for what's happening. But the CRA, the Congressional Review Act, as I said, was enacted in the late 90s. And it's a really streamlined way for Congress to overturn rules they don't like. And in fact, in 2016, when the Trump administration came in, there were some rules that have been passed in the last year of the Obama administration, because Republicans controlled the White House in both chambers. They got rid of, I think it was about 18 different Obama rules. So that same thing can happen again at the end of this year if the Biden administration takes quite extra long time to push out the rules that they have pending, including some of the ones that you've seen on the screen. So looking at the Obama fiduciary rule, and the current one being proposed is roughly analogous, at least in terms of the definition of a fiduciary, because it would broaden it to include commission-based advisors who meet certain criteria. But essentially, like the Obama fiduciary rule, it would create thousands of new ERISA fiduciaries who rely on commission to sell insurance products or other investment products. So Congress didn't like the Obama rule during the Trump administration. And so they used it to try and overturn it. Now, well, I'm sorry, that was in, well, this was, this was in 2016, before the Trump administration came in. It was approved in April of 2016. And by June, just a couple of months later, Congress used it's a joint resolution to try and overturn that rule. And as you can see, the language in the upper right, the joint resolution is used for any rule that's involved. They just simply put in the name of the rule, as you can see on the last 3 lines there. This was the definition of the term fiduciary. And they just needed a simple majority to overturn it in each chamber. They didn't have, you can't amend it. You just either overturn the whole thing or not. But it was vetoed by President Obama, and vetoes are rarely overturned. So what happened, and here's the outcome of the effort to overturn the Obama fiduciary rule. At the bottom of the slide, you had 239 Republican votes, 180, but you needed 2/3 to overturn it. So that bill died, that resolution to overturn the Obama fiduciary rule died. And looking at the current rule that's in play, you had only 60 days for a comment period of roughly the same type of rule that ended January 2nd. And so right now, the Department of Labor is looking at the thousands of comment letters, primarily the ones that were submitted by trade groups, including FPA. I know you all had one in there. If they don't get that rule approved by June, and the election results turn out to have Republicans, let's say, in control of both chambers in the White House next year, then that rule would be probably open for being overturned under the Congressional Review Act. So earlier, when I showed you the SEC rules that impact investment advisors, when you look at the OMB dashboard that shows the SEC expects to approve those rules by April, that's not a coincidence. All of them have an April deadline. That doesn't mean they're going to be approved then, but I think it's pretty obvious, because if they wait too long, if they, on these new rules, if they get into June, July, and so forth, it cuts over into what's a 60 legislative day deadline. If they get into that area, 60 days, you might, if you count back from December, you might say, oh, well, that would be in the early fall. But no, they don't, Congress doesn't meet that often. They'll meet 3 days a week. They'll take off August for recess and so forth. So 60 legislatives going back at the end of a Congress can end up being in June, maybe even May. So that's why you see the Biden administration, not just the SEC, but in the DOL, but all the agencies pushing hard to try and get their rules out so they aren't impacted by the CRA. So we'll have to see what happens. But at the same time, going back to 2016, when the Republican-controlled Congress was attempting to overturn the Obama fiduciary rule, the industry groups filed a whole bunch of lawsuits in federal court to overturn the rule, because that's the other way to get at a rule you don't like. There were 6 lawsuits filed against the rule in four different federal circuits. And at first, if you can see those little headlines I have over to the right by the map of the circuits, the DOL was winning left and right. The first headline at the top, November 7th, 2016. These are headlines from Bloomberg Law. First fiduciary rule challenge leads to thorough DOL victory. Another one in February in I think this is a Kansas district court. DOL retains perfect record in fiduciary rule challenges and so forth. They were winning left and right, but in the rule, there was 4 or 5 different trade groups that filed in the Fifth Circuit, and the district court judge dismissed the rule. It was appealed to the Fifth Circuit Court of Appeals in New Orleans, and that's where the big news came out in March of 2018, that the rule was vacated in its entirety. So I mentioned the Fifth Circuit a little bit earlier. So why the Fifth Circuit? This is partly opinion. Okay, we're running out of time. So I'll just say that the judges don't necessarily always vote by, their party, but there's a reason business groups go to the Fifth Circuit. And when you look at this in the Northern District of Texas, where these suits were filed, 15 Republican judges, appointed judges, 2 appointed Democrats, actually, and it's a random selection among the judges. It was a Democrat that got the initial complaints from the industry groups to want to overturn the Obama rule. And that judge dismissed it, but then it was appealed. And when you look at the Fifth Circuit, there's about a 1 in 3 chance that you'll get a Democrat. And it was actually a split. There were 2 Republicans and 1 Democrat on the Fifth Circuit, and the Democrat dissented from the final decision that overturned it. So with that, I just put some predictions on here that I think I gave last year. Things don't necessarily change. Gridlock we're likely to have. You never know. We could have some big surprises in the election. But if you have at least divided government is defined as either one party controlling one chamber or the White House. And if you have that, it's going to make it difficult to pass major legislation outside of your typical appropriation bills, naming a post office and all these minor things. So I don't see a whole lot happen. In fact, and this was in the press, the House of Representatives for last year set a not very enviable record of having the lowest production in over 20 or 30 years in terms of they passed 27 laws out of 724 votes that were taken. Federal agencies, I didn't get into the Chevron test, but there's some other court cases going up at the Supreme Court that can make it more difficult for agencies to defend their rules when they're sued. So I see a lot of that gridlock trickling down to the Department of Labor and SEC if there's a lot of partisan disagreement over some of the rules that we saw that the SEC has, and of course the Department of Labor they do take sides. Professional regulation of financial planners, I think that's where it becomes increasingly important to look at your private sector regulator because that's one place where you have an assurance that the CFP Board of Standards rules are going to always have to be at a higher level than what the law requires. And so I would always look there first to see what your obligations are, especially since their laws are applicable to financial planners. So with that, hope there's a little bit of time for some Q&A. Skip, you're on mute.
Oh, apologize. After 3 years, I should know that. You really teased me with that photograph that you just brushed past there at the end. Can we spend 15 seconds on that?
Yeah. Oh, I'm sorry. Let me just say I circled somebody. That was the press conference for President Biden announcing the Department of Labor rule, and I circled this one suspect there whose name is Dan Moyzan. I think a lot of you know him. So I think that shows that, maybe 15 years ago, you wouldn't have seen a CFP or an FPA member at that level at a White House conference. So just another example. And sorry, Skip, I'm glad you raised that out. I don't see Dan on this, but I wanted to give him a shout out. And the same thing happened with Cheryl Garrett. In 2016, she was singled out by President Obama as the quote, one of the good advisors when they adopted the earlier fiduciary rule. So thank you.
Yeah, Dwayne, thank you very much for
You're
that.
welcome.
It's great to get your inside views of things that are coming down the pike that could impact us. So questions from the esteemed audience.
You have Glenn with his hand raised.
Thank you, Glenn. And you can either enter them in the chat or do as Glenn did and raise your digital hand, and then your window will rise to the top of my screen and I'll see you. So go ahead, Glenn.
I know this year RIAs have a CE requirement in California and several other states. And I was wondering if you've looked at that. And I know in California, I believe it's Series 65 is exempt if you're a CFP. So I was wondering if you're looking at maybe trying to exempt this CE requirement if you're a CFP.
Well, that's probably a question more for Lauren. The only thing I'll say is that was a state model rule where whether you're affiliated with an SEC registered advisory firm or a state firm, states do have the authority to regulate qualifications for an investment advisor representative. And the states, I don't know how many states have adopted this model rule, but it requires 10 hours, half of knowledge of markets and half on ethics and law. And so it's slowly being rolled out by the states. And I know it's a big headache, especially for trade associations and chapters and so forth that sponsor programs that need to get run through NASA or the states and get approved in order to get credit for those. And I'm not aware of any exemptions for if you you might have been referring to the waiver for taking the Series 65 exam. And
I mean, I don't believe there is. I'm just wondering if you were working on one. I thought this was broader than.
The CE, it's a model rule, and it's up to each state to adopt it. And I know NASA is the State Securities Regulators Association is pushing all the states to adopt it. And I don't know where it is in California.
Let's get to Kurt Wheel, who is a longtime leader in our profession and generous contributor to the FPA PAC as well.
So Dwayne, it's nice to see you. I'm curious about the resistance to subscription fees. What seems to be the bee in the bonnet of those who don't like it?
There's I think an unfounded concern or fear among some state securities regulators that you can sign up for this. The concern is what they would consider reverse churning. And as financial planners, you're not necessarily working with all your clients every single month. It's unpredictable. When they have a life-changing event, that's when they're going to come to you to get work. The states, when the state securities examiners, when they go out and look at your activities, your client communications, they may see that with a given client, you didn't do anything with them for 8 months or so. So it's important, I think, and again, I'm working with XY Planning Network, and to a certain extent, I've worked with FPA and CFP Board and NAFA on this issue. It depends. NAFA, XYPN, it's a big deal because they're pretty much 100% subscription. They don't do AUM or much hourly and so forth. But some of the states have this unfounded fear about getting money and not providing any services. And another issue for them is because you're collecting more than, I forget what it is, $500 in advance, whether that triggers a custody rule under state law. So I think it's going to be a growing problem for state securities regulators who view this subscription fees as a potential reverse churning type issue. On the other hand, for especially younger people who don't have the type of asset minimums that some financial planners and investment advisors require in order to provide them with services, subscription fee, there's no minimum. So it can be a big help to individuals, young people especially, who are just getting started out and have the best shot at saving, becoming financially independent and so forth later on in life if they begin with a financial planner early in life. So it's a little bit of some of the main issues involved. And there's only a handful of states that I'm aware of that they go in, they look at it, and they're making deficiencies and all that. I think it's going to come to a head in the state where someone, I think in Utah, for example, they have a cap of, I think it's $300, $250 or $300 equivalent hourly fees. And so it's a problem, especially if you have to register in the state because you have more than 5 clients. And let's say you're in New York where you charge more than that. They have a ban on that. So you have to come up with a different Form 80V to provide those same services to your clients and charge a lower fee in Utah. It's going to be a real pain for a lot of people over time if NASA doesn't understand the benefits of it.
Thank you. Thank you. Good to see you, by the way.
Yes, good to see you, Kurt.
We are out of time. I'll just close with a couple things. James Lee pointed out that some doctors now charge monthly fees for concierge services. Is this a point we could use in our favor? Lauren points out lawyers use retainers all the time. So I think those are some points we should be considering in our efforts around influencing that policy. We are, as I said, out of time. Thank you everyone for participating today. It's great to see all the familiar faces. And remember fpapac.org, fpapac.org.